I've got 701.
Should be a 1745.
There should be.
That's right.
There,
Not makes you get me on it.
we call 24 CR 701, the state of Texas versus Larry N.
We have got a double plea deal on the table today and things move fast, but don't let that speed fool you. What you are about to hear is a felony assault case against a public servant, which, under Texas law, that's a third-degree felony. Let's break down what that really means.
Green Jr., that's you, sir?
Yes, sir.
Present with your attorney, state's attorney, Mr. Reynolds, does the defendant waive a formal reading of the indictment and arraignment here? Can we proceed in summary?
So wait.
In summary, this indictment alleges that on or about February 15th, 2024 in Jefferson County, Texas, you committed the third-degree felony of assault on a public servant. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may...
Pause here. Did you catch that? Up to $10,000 in fines and a possible decade behind bars. And yet, he's taking a deal for just 5 years. This suggests one thing: either the evidence is stacked high, or the defense knows a trial would be a train wreck.
be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached. You would be pleading guilty, sentenced to 5 years in prison to run from charter with 1745. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this? Guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney? Or the contents true and correct?
Yes, sir.
State's Exhibit 1 tendered in
No
evidence
objections.
without objection to evidence. Among other things, the state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any less than treated offenses. You were giving up your rights to a free trial. The rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All through, so help you God.
So far, everything sounds routine. But take a moment. This man just pled guilty to assaulting someone sworn to protect the public. What happened? We do not get the details here, but if you were the judge, would 5 years feel fair? Drop your take in the comments.
So, State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report waived on this case.
So it is, Judge.
All right. I'm going to hold that in abeyance just for a second. I'm going to go to 24 CR 1745. Again, does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
He doesn't.
In summary, in this case,
I apologize for interrupting, but you will need counts 1 and 2 for this one. I think the paperwork's just 1, but because of the nature of this offense, we need 1 and 2. It's a violation of protective order. In order for it to be a felony offense, there has to be prior offenses of that nature, which is referenced in count 2.
protective order violations.
Yes, sir.
Okay.
Hold up, this isn't it. Just one case. WAR now flipping back to a second indictment. Violation of a protective order. And not just once. Multiple times. Under Texas law, stacking prior convictions like this upgrades the charge from misdemeanor to felony. This just got serious.
Paragraph 1 alleges that on or about July 9th, 2024 in Jefferson County, Texas, you committed the offense of violating a protective order. Do you understand what you're charged with, sir?
Yes, sir.
Paragraph 2 goes on to allege that on March 27th, 2024, you were convicted in 2 cases in the County Court of Law 2 of Jefferson County, Texas, and this was before committing the offense alleged in paragraph 1. You were convicted of violations of protective orders in those 2 cases. Do you understand what you're charged with in paragraphs 1 and 2,
Yes, sir.
which constitute a third-degree felony? And you're facing no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. Do you understand all of that, sir?
Yes, sir.
And also an agreement's been reached in your case. Similarly as the previous case, you would be sentenced to 5 years in prison for paragraphs 1 and 2 of the indictment, which constitute a third-degree felony. If I follow that agreement, you have no right of appeal. Is all of that true, sir?
Yes, sir.
How do you plead to this? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I'm going to show you what's marked as State's Exhibit 1. Did you sign this agreement? State's Exhibit 1. Understand it, discuss it with your attorney, or the contents true and correct.
Yes, sir.
State's Exhibit 1 tendered into evidence.
No objection.
Admitted. As before, this again states you were pleading guilty voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 here to find you guilty beyond a reasonable.
Let's pause. What's the cost of violating someone's safety twice? Here, 5 more years. No trial, no cross-examining witnesses. Just a signed document and a guilty plea. This courtroom is just moving fast, it's cleaning house. Would you have handled this any differently?
And you're giving up all rights of appeal. If I follow this agreement here, you need to sign the bottom of it, buddy. Well, pre-sentence reports waived in each of these cases. So wait. All right. Again, I've already made findings in 701 and 1745. The court finds you have pleaded guilty and true to paragraphs 1 and 2. Voluntarily, knowingly, intelligently, this indictment, which constitute the state jail felony, the 3rd-degree felony of violating the protective order. You're waiving your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You're totally satisfied with the representation provided by your lawyer. All of that is true, so help you God. Yes, sir. State's Exhibit 1, part of the record for all purposes. I'm going to follow these agreements of 5 years in prison in each of these cases, and pleaded voluntarily, guilty voluntarily, knowingly, intelligently to each of the good agreements. You're mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 in each of these cases that finds you guilty beyond a reasonable doubt, and I now find you guilty in each of these 2 cases. I'm following these agreements.
And there it is, the gavel drops. 5 years per case. That's a total of 10 years. But the real story here is how smoothly this entire process went. 2 serious felonies, 0 courtroom drama. But is that justice or just efficiency? Think about that.
You hereby sentence to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years on each of these cases. These sentences shall run concurrently. Do you understand what has happened today, sir? Thank you. That is all. For tomorrow, so we can talk about what's going on here.
Mr. Powell, I need you to stand in front of me, please. Right hand, you swear or affirm to tell the truth, the whole truth, and nothing but the truth, self you got?
Yes, ma'am.
Okay.